Breaking news out of the Supreme Court, big implications for reproductive rights. The justices unanimously right now upholding changes to regulations regarding the abortion pill, Mifepristone. But it says that they can stay on the market as is. There was a challenge by a group of doctors who asked the court to restrict access. I'm joined now by Jarrett, our senior legal correspondent, as well as Cevallos. So this is a case that was tossed out essentially on technicality or the issue of standing, whether this group of doctors had the right to sue. And the bottom line is this expanded access in 2016 and 2021 for the abortion pill Mifepristone, that expanded access can stay as is.
Yeah, so let's back up just a little bit. This was a group filed by essentially anti-abortion advocates and doctors who wanted to take the pill off the market completely. It's been winding its way through the federal courts for the better part of a year now. But here the high court has said that it was going to stay on the market as is. In other words, no change to the pill. The most urgent piece of this was whether the pill would be unavailable by mail, which has been a huge thing. And obviously, it's the most commonly used pill in the entire country. And that would have been a huge restriction. But today, the court saying they don't even need to reach that issue because the group that sued doesn't have standing. That means they don't have the legal right to sue. These were people who didn't want to use the pill. These are doctors who never wanted to prescribe the pill. These were people who just objected to it and said that the FDA didn't do enough to look at the safety issues around the drug. By the way, the FDA says the drug is incredibly safe and has very little side effects. The court doesn't need to reach that issue because of the standing. And it would have had enormous implications, not just for the abortion pill, which is so widely used, but for every FDA-approved drug. That's why the Biden administration was fighting so hard to keep it on the market. So we're going to work our way through the decision, but we should mention it is unanimous.
Yeah, so this is in 2000, this pill was approved by the FDA, but in 2016, Danny, and in 2021, the Biden administration expanded access, so you didn't have to go to the doctor personally 3 times and so forth. And then, as Laura mentioned, made it available via telehealth in 2021. The court did not reach the merits of the FDA's decision, simply stating that this group of doctors who sued did not have the legal right to sue.
Standing is a constitutional requirement. It really asks the question, does the plaintiff have any business or any real interest in this outcome? Can the court even offer relief to this plaintiff? Or is this plaintiff just somebody, a citizen, who just cares about something, but it doesn't really affect them? And it really answered a very interesting question, which was posed by the plaintiffs, which is, well, if we don't have standing, what if nobody has standing? What if nobody can ever challenge FDA in court like this? This came up at oral argument, which was, I would say, mostly devoted to the issue of standing more than the merits. And what's an interesting conclusion by the court in this opinion is that there will be times when nobody has standing to challenge something like FDA. And the solution may not be the courts. The solution may be the political process or some other avenue, maybe even internal review by FDA itself. But a very interesting holding within this opinion is that sometimes there is no standing to challenge an FDA action or something else.
So if you don't like it, you may have to petition Congress to do something about it legislatively.
Thanks for watching. Stay updated about breaking news and top stories on the NBC News app or follow us on social media.